Greetings everyone, Jonathan here from Plagiarism. Today, usual Google Plus profile link below. I'm going to forgo the usual upbeat intro today because today we're going to talk about something that's obviously very sad and has weighed on a lot of people, and that is the case of Aaron Swartz. Now, I've held off on talking about this case and what took place in it for a good while now, and there's three key reasons for it. The first reason is out of respect. Aaron Swartz was a human being. He died very tragically. It is a very sad situation, and I did not feel it would be appropriate for me to offer comment on it so soon after his passing. It would not seem right to me. Others who knew him felt had better things to say and more appropriate things to say, but to me, I personally would have felt if I had said something sooner, it would have just been a cheap capitalization attempt on a tragedy, and I didn't want to do that. The second reason is I really don't have a lot to say on the case, frankly. Aaron Swartz was being prosecuted underneath the Computer Fraud and Abuse Act, not copyright law. A lot of people are conflating this with a copyright case, but the charges against Swartz did not, and the allegations, I should say, against Swartz did not hold up to a criminal copyright case. So he was being charged under the Computer Fraud and Abuse Act, the CFAA, and I'm not an expert on the CFAA. Just going to say that right now. I know what the law is. I know the sort of the generals about it, but I don't know the law as deeply and as intimately as I know copyright. I've been studying copyright. I've been involved in copyright for well over a decade now. I have not been that intimate with the CFAA, so I don't have any great comment. There's plenty of people out there very, very well versed in this law. They deserve to have the spotlight on those issues, not me. And the third reason I've kind of been taking a back seat to it is that emotions have been running very high through this, and I don't want to upset anyone, and I want to talk about sort of a very narrow element of this that I've been thinking about, but I don't want, the anger and the frustration through it all to sort of prevent people from taking a look at this. Because even though what I'm saying is not critical of Swartz at all, a lot of the argument, especially in the beginning, was mostly emotional based, and it's only now with some time more logical, rational arguments have really begun to take place. And I'm hoping I can say at least a little something on that might get people thinking about what I believe is a very important but overlooked issue in this. And the issue actually deals with the prosecutor in this case. Ortiz is her name. There's allegations that she was overly aggressive, that she really was unbalanced and unhinged in her prosecution of Swartz, and I don't know. This is something else I can't talk about. I don't know if those allegations are true. I've seen people talking on both sides of the issue, but I'm not going to offer my opinion. But there are calls out there to fire her, and in fact, there's a petition at whitehouse.gov to try to get her dismissed. And all of that is very interesting, but it's not going to resolve the problem. And that's just it, because if you get rid of her, there's literally hundreds of other prosecutors out there that would have done the exact same thing in her position. I mean, quite literally. And I'll explain why real fast. Because in the United States, we have what is known as an adversarial legal system. That means there are two sides that are opposed to one another. The prosecution, and we're doing criminal cases here, the prosecution and the defense. These two sides are opposed to each other, and they both have the same objective: to win. You can summarize both of their jobs with the same two words: to win. They both want to win. Now, that means if you want justice, if you want fairness, you've got the judge and the jury in the courtroom to represent those interests. It's not going to be the prosecutor or the defense. But that doesn't mean, of course, the prosecutor has to be totally unhinged with everything he or she does, etc. So, there has to be some balance there, and there are rules, regulations, and ethics there to provide that, but obviously it's not perfect. But the issue that I see is sort of defining to win. Because how do you define that job? To win. I mean, what does winning mean in a courtroom? Well, for the defense, it's actually pretty clear. The defense, it's to represent the interest of their client. I mean, that's who they go there to represent. And that means getting them through the legal ordeal with as little headache and as little problem as possible. For the prosecution, they're representing the interest of the state. And by state, I mean the government. And it's very unclear what the interests of the state and the government are. In fact, what is in the interest of the state or the government is actually a hot political discussion a lot of the time. So what does it mean to be doing something that represents the interests of the state? Most prosecutors don't know that, and it's very difficult for them to make their case that what they're doing is or is not. And so for prosecutors, what they're often held to is a standard of how many convictions are you getting and what percentage of cases that you bring are you getting convictions in. That ends up being the standard. It's a bit like teachers, being held accountable to test scores and almost nothing else. It's a very simple, very basic metric that doesn't really gauge how well the prosecutor is representing the interests of the state, but it's the only metric we have, so we base so much on it. That's ridiculous. And let me give you an example of this and how this can create some pretty odd results. A couple of years ago, my wife got her first speeding ticket. I know, she'd been driving for like 10 years or so and never gotten a speeding ticket. But anyway, she got a speeding ticket. And I was in the car with her, and we were taking the dog to the vet, actually. And I'll spare all the details, but basically we felt the ticket was questionable. There was a lot of reason for us to be doubtful, and we felt we had a pretty good case. So we decided we were going to fight it. We went down to the courthouse with our lawyer, prepared to duke this out, and after an exchange with the prosecutor, it was decided, hey, we would plead guilty to a seatbelt violation. Now, this is very odd because, while you can debate whether or not there was speeding, I mean, a million things could have happened between our perception of how fast we were going, how fast we actually were going, and the police officer's perception of how fast we were going. There's a million things that can go wrong. Every living creature in that car had a seatbelt on. I had one, she had one, even the dog with its harness had a seatbelt on. There was no seatbelt violation, but we pleaded guilty to it. Why? It was a $15 fine, it wouldn't raise our insurance, and it got us out of there within 10 minutes. The result, even with our legal fees, we probably got out several $100s cheaper before we even factor in the possibility of an insurance hike. Now, for me, that's a win. I mean, $15, take it. Screw it, I don't care. For the prosecutor, though, it's also a win. They got a conviction. She pleaded guilty to something. She got her. It's a win. And it's a very bizarre way to look at it, but it shows how the two sides don't have the same metrics for what it means to win. This leads prosecutors to be very aggressive about getting something, a conviction, anything, pushing, trying to nail people. And it's not just Aaron Swartz, it's anyone they feel they can get a conviction out of, they're going to go after. And they're going to go after hard. But it also leads to decisions in the opposite direction, too. And that means, if a case is going to be very tough, it's going to be long, it's going to take a lot of resources, a lot of time, they might be motivated to take a very bad deal or a very weak deal, give them sort of a slap on the wrist, just to A, get the conviction, and B, end the case. So this motivation to get a conviction, the desire to get something, to get them no matter how little or how big or whatever, that's what's motivating prosecutors. And that's dangerous. We, as a country, what Aaron Swartz, prosecutor, did or did not do. Like I said, I don't know if she acted overly aggressively or did anything illegal or immoral. But I have a conversation about how we judge the effectiveness of prosecutors, because I think it's going to be something that, until we resolve that issue, good or otherwise, isn't going to fix the problem. We're going to have a justice system that's clearly unbalanced and unhinged. So, just a warning to you guys. That's all I wanted to say on it. That'll be the last time I'm planning on discussing Aaron Swartz. Until then, thank you very much for watching. Until tomorrow, this is Jonathan Bailey, signing off.